that they use that picks up the audio and the video doesn't pick up the movie. Comes out of the same computer. I don't know why it wouldn't, but maybe there's some technological reason why they didn't pick it. And the other reason is maybe YouTube has some kind of a filter that sets off alarms when it looks like copyrighted material is being uploaded. No, I don't think so. I don't know. But if you guys have an explanation, I'd be curious to know what it is. Say again? I don't think they edited the thing, no. I mean, there's a delay from this morning till tonight before they put it up. But I don't think they've got people, actual people, looking at this stuff and say, oh, we better not do that. They might. I don't know. John? Sure. Yeah, no, I'm sure they're sensitive to it. Aaron, I think who owns the copyright, Facebook or you? The picture of you doing something ridiculous is not really relevant to the privacy issue. And if you posted the picture of you doing something ridiculous, you're under the Moreno precedent, your right to privacy is gone with regard to that picture, regardless of who owns the copyright. And then Moreno's family members sued. They were hurt by this publication. They were injured. They had damages because of this publication. And the court concludes, quite properly, that they have no claim to invasion of privacy by virtue of the newspaper running the Ode to Coalinga, because the right to privacy, this right to privacy, is entirely personal. Only the person whose privacy has been invaded has a right to sue for invasion of privacy. And I'm sure you're thinking, well, what about a corporation? Now that corporations are persons, can they sue for invasion of privacy? And I think the answer to that is no. They're not the kind of person whose privacy was invaded. There was a case in the Supreme Court last year in which AT&T claimed that privacy interests would be infringed if they had to disclose certain information. And the court said, no, that the kind of privacy we're talking about, this was under the Freedom of Information Act, is personal privacy, not corporate personhood privacy. So that neither the family nor Cynthia Moreno succeeded in their privacy claims. Then what about the First Amendment? Oh, and they also said that Cynthia Moreno's name was not a private fact. So the disclosure of her name in the newspaper editor, giving her the byline, in fact, was not a private fact by itself that allowed her to bring a suit for invasion of privacy. Then what about the disclosure of, for example, the name of a victim of a sexual assault or a rape? And that leads us to the First Amendment, because the Supreme Court has decided a couple of cases involving the disclosure of the identity of a victim of a sexual assault. And the case that I put in the reader is the BJF case. Well, that's what I had to say about Moreno. But BJF, the court treated her name as confidential, lived in Jacksonville, Florida, and was raped. And the perpetrator was not caught. And the local newspaper, the Florida Star, weekly newspaper, sent somebody like you, a trainee, an intern, down to the police station every week to look at the police blotter, to look at the bulletin board in the police station, and copy down police reports that were put up on the bulletin board for that week. And the intern went down to the station one week and copied down verbatim the report of BJF's rape. And the newspaper, even though it had a policy of not reporting the names of victims of sex offenses, simply converted that trainee's report into a news story somewhere back in the back pages of the newspaper and included BJF's name in the story. She sued under a Florida law that provides that it was illegal to print, publish, or broadcast in any instrument of mass communication the name of the victim of a sexual offense. And the newspaper is an instrument of mass communication. BJF alleges in her lawsuit that her mother had received several threatening phone calls from a man who said he would rape BJF again, and that all of this had forced her to change her phone number and her residence, to seek police protection, and to obtain mental health counseling. She was emotionally distressed by the disclosure of her name in connection with this ugly event. The case went to trial, and she was awarded $75,000 in compensatory damages and $25,000 in punitive damages. Not big bucks, but this was a long time ago. And the case went to the Supreme Court, having to decide whether the First Amendment protected the newspaper from liability for having published truthful information, BJF's name, in connection with its report of this crime in the town. And I remember when the court granted certiorari, I said to myself, why are they bothering with this? They've already decided this in a case called Cohn versus Cox Broadcasting Company some years earlier, which involved the disclosure of the identity of a rape victim by a local television station in Georgia. And the court had decided that that disclosure was protected by the First Amendment. The Cohn case involved the tort of publication of private facts. BJF's case didn't. It involved a claim under this Florida statute that they had simply published her name in an instrument of mass communication. I thought that the Cohn Broadcasting case was binding precedent, and the court, how could the court avoid coming out the same way? Why did they bother with this new case? But as you see in Justice Marshall's opinion, the court made a very fine distinction that Cox Broadcasting cannot fairly be read as controlling here, because in the Cohn case, in the Cox Broadcasting case, the press got the information from court records, from records that were publicly available in court. What happened, in fact, was a reporter for the television station went up to the clerk of the court and looked at the indictment, which stated the name of the victim. And that's the way the press got the information in Cox Broadcasting. While in the BJF case, Justice Marshall says there was no proceeding here. There was no trial going on. There was nothing in court. They hadn't caught the perpetrator. They didn't know who he was. No suspect had even been identified. And therefore, Cox Broadcasting was not, at least not necessarily, binding precedent for the decision in BJF. And then the court looks at the argument from the press, which was broad and dramatic. That is that the First Amendment protects us whenever we publish, whether it's civilly or criminally. We're protected for publishing when we publish the truth. As a categorical matter, if we publish the truth, the First Amendment bars any liability, public record or not. And the court rejects that broad contention, recognizing that that would wipe out the tort of publication of private facts, because by definition you're talking about publication of the truth. So the court doesn't want to go whole hog in favor of the press by saying publish the truth, you're off scot-free, and doesn't want to say that Cone protects the press here because it's different, factually different from the BJF situation. Rather, Justice Marshall says we're going to use some limited principles that sweep no more broadly than the appropriate context of the instant case. So this is modern Supreme Court First Amendment adjudication technique. Decide the case as narrow, put aside Citizens United, as narrowly as possible, in as fact-specific a way as possible to limit its precedential value. What the court did look at is the precedent that it set in Smith versus Daily Mail, which was a case that involved the criminal prosecution of newspapers for violating a state law that prohibited publishing the name of a juvenile court defendant. Juvenile court proceedings were supposed to be confidential. The newspapers had found out who was being charged with a serious crime, and they published it and were criminally prosecuted for it. And the court said, no, the First Amendment protects them from that. And in the Smith versus Daily Mail case, the court elaborated an analysis, which it then adopts in BJF. And the analysis is, if the press publishes truthful information that is lawfully obtained, that is, they didn't bribe somebody to get the information, they didn't burglarize somebody's office to get the information, they didn't do anything illegal to get the information. It's truthful information, lawfully obtained, and the information is about a matter of public concern. It's not quite to say newsworthy, but it's about a matter of public concern. Then the First Amendment bars liability unless the other side can show that there's a need to serve a state interest of the highest order. So how does that analysis apply in the BJF case? Justice Marshall says the Daily Mail analysis clearly commands reversal. The Florida Star got the information lawfully. They sent the intern down to the police station into a press room that is available and open to the public, where the intern copied down the information that the police had posted there. Nothing illegal in any way about the acquisition of the information. It was unquestionably truthful. They got her name right. It was truthful information, lawfully obtained. Then is it about a matter of public concern? Not the question of whether her name is of public concern, but is the story about a matter of public concern? And the court said, yes, the commission of a very serious crime like rape is a matter of public concern, and the press should not be faulted for having published it. So those three parts of the Smith versus Daily Mail test were met. Truthful information lawfully obtained about a matter of public concern. And then the question is there a need, Florida says there is, to impose liability on the newspaper in order to protect state interests of the highest order? And the court then launches into this modern First Amendment analysis of looking at what the state interests are and seeing if there's a good fit between this law, that it automatically imposes liability on a newspaper that publishes the name of a rape victim, and the state interests in protecting privacy of victims of sexual offenses. And that analysis is going to take longer than what we have today, so we'll finish it up on Thursday with the rest of the privacy stuff.